Yes, please.
Now I will start my case on 2 points that whether the CPC is applicable or not. The spirit of CPC, exactly we cannot say that the entire CPC is applicable, whether the spirit of CPC was applicable or not, my lord. So if CPC was applicable, then the concerned authority also could have entertained the review application, my lord. Now, my lord, before I go into the merit of the case, I kindly come to two judgments that I have given. If my lord may kindly take up Munising T Sangma, my lord.
Okay. Yes. Order dated 21.
My lord, may I kindly come to para 5, my lord.
Yes.
My lord, after hearing the submission advanced by the learned counsel for the parties, I am of the constitution view that since the dispute is between the parties of the Nokmaship, it just cannot be decided without framing of issues and taking any evidence. Therefore, I felt that in this type of matter, the provision of CPC should guide the Chief Executive Member, Garo's Autonomous District Council.
Yes.
So, the settled law at present, my lord, and this law has not been challenged, my lord, and this is a settled law, that CPC is applicable and CPC, this EM and CM should be guided by CPC, my lord. If that is the case and this is a settled law, my lord, then the first part of my learned friends' grievances I have answered, my lord, that why review can be entertained, my lord. The law says that it can be, my lord. The second part, my lord, before I go into the facts of the case, my lord, if my lord may kindly take up Chalis Sangma judgment.
This is
Chalis Sangma. CAG IS Chalis Sangma. If my lord may kindly see para 4 first, my lord, page 3.
yes.
The learned single judge has mentioned the graphic statement of facts of the writ petitioner, that is, principal respondent, and also to a verbal submission of facts by the learned counsel appearing for the appellant in the impugned judgment and order dated so and so. The operative portion of the judgment and the order dated so and so of the learned single judge, which dealt with the fact of the case as quoted hereunder. This case has been, my lord, we can skip, my lord, the entire thing, the last
Go
3
only-
lines.
Go only to the relevant portion.
Yes, my lord. The last 3 lines, my lord.
Yes.
According to the petitioners,
Last 3 lines.
yes, the last line, according, my lord, that quoted, according to the petitioner,
Yes.
the last 3 lines, my lord. Page 3, my lord.
Yes, page 3. No?
Page 3, the quoted portion, my lord.
According to the prisoner, they are the legal heirs.
Yes, my lord. Legal heirs of the last recorded Nokma of the Aking name, namely so and so, the late Rasen Mara and late Thame A Sangma, and direct decision of the said last recorded Nokma, they were also elected by the whole Aking so and so clan. In the case of the petitioner, the respondent number 5 and respondent number 6 have no legal right to claim the Nokmaship as per the Garo customary in as much as they are not the legal heirs of the last recorded Nokma, namely late Rasen Nokma and Thame Sangma, nor were they elected by any clan member, people of the Aking land. So and so. According to the petitioner, Dome Sangma is the daughter of the late Thame Sangma and Rasen Mara, and the Dome Sangma is the wife of late Parkin Mara. And after that of Parkin Sangma, the petitioner number 1, who is their daughter, married the petitioner number 2. After the application was filed by the petitioner, the district council directed the Mozadar to conduct an inquiry and submit his report. The Mozadar submitted his report dated so and so and took the statement of the Mahari, Chra and so and so. It is claimed by the petitioner that in the year 1937, the Deputy Commissioner, Garo Hills, by order dated so and so, has declared the late Rasen Mara as the Nokma of the Aki. The EM, by the order dated so and so, disposed of the case by declaring the respondent number 5 and 6 as the Nokma. Agreed by this order, the petitioner took the matter to appeal before the CEM, which was registered as GHDC Revenue Aking appeal case number so and so. After hearing the parties, the CEM, by the impugn order, dismissed the appeal and upheld the judgment of the EM. This is how this writ has been filed before the court for appropriate relief. No affidavit in opposition filed by the respondent. However, A. Paul, the learned counsel for the private respondent, reply on the lower court record, extensively argued the case in the course of the hearing and defended the impugn order and judgment of the CEM and EM and prayed for dismissal of the writ with cost. Now, my lord, there is a similar situated case where, my lord, the mother and father has never claimed. Now it is the granddaughter who is claiming, my lord, in this matter also, and exactly the similar case, my lord, of the petitioner. Now, my lord, may kindly come to page para 14, my lord. Page 18, my lord. In the present writ proceeding, keeping in view of the above observation regarding the Garo customary law, we have accepted the submission of the learned counsel appearing for the parties that the Garo follow matrimonial system of inheritance of the property, and when the woman dies and survived by her Nokna, the property vested in Nokna, who is not compulsorily the youngest daughter as the Nokna, in the favorite daughter among the daughters chosen by the parents during their lifetime to inherit the property. In the present case, there is no material evidence or assertion of the parties that Nime Sangma Michik and her husband Kiljing Mara had chosen one of their daughter among the 3 daughters as Nokna. Now, what is this point is saying is this. Now, the parents of the petitioner has never decided that the petitioner will be the Nokma, my lord. So she cannot claim that she can be a Nokma, my lord. Now it has to be decided by the last recorded Nokma, my lord, who will be the Nokma who will inherit the property, my lord. In such case, Nokna may be the one selected by the Chra of the deceased wife and Mahari. In the present case, it is clear that the order of the Deputy Commissioner dated so and so, the Mahari and Chra has no objection to the entry of Rasen Mara as Nokma. Normally the name of the husband and wife are entered as Nokma of the Aki in the record, and such decision of the Deputy Commissioner Garo Hills had not been challenged and not converted to more than 70 years and have been followed. Now, my lord, this point again, my lord, there was a gap, my lord, of so many years where they are coming forward now, my lord, to claim that Nokmaship. Now, if I go to the facts of the case, my lord, I would like to take, my lord, from the beginning, my lord. My lord, may kindly see page 24, annexure 1, my lord. Page 24, annexure 1.
Yes.
my lord, this is the GT which they have encloses. My lord may see Rabin Sangma, who was the wife, who was the husband of Nosing Marak, my lord, Michik.
Yes.
And after that, my lord, their name has entered. The name of the petitioner has entered, my lord. And how the name of the petitioner has entered, my lord? By suppressing the fact that they are the daughters and son-in-law of Rabin and Nosin Marak, my lord. It is not they are claiming that we are the grandson and granddaughter of the last recorded Nokma, so we should be in the list, my lord. They have suppressed that fact and it is a matter of record, my lord. My lord, may kindly come to page 27. This is the letter of 1965, my lord. How Rabin and his wife become the Nokma, my lord.
Yes.
With due respect, I humbly submit that the report regarding Rabin Sangma, the son-in-law of so-and-so of Rongmalgiri, so-and-so village, the Rabin Sangma's wife, so-and-so has already expired, and a clan member, together with one mind, my lord, may kindly consider, with one mind, had substituted Nosing Mara for the same clan as the wife of point that the property should revolve around the same clan is not a question here, my lord, because they have given the same from the same clan. Now, if Rabin Sangma was given a substituted wife as the petitioner's mother, my lord, then she has a claim, my lord. That was not done by the Mahari, my lord. The Mahari is the authority who decide, my lord, along with the last recorded Nokma, who will be the next successor, my lord. Now, my lord, may kindly see, as per the Garo custom, and the clan members has voted for Nosing Marak to be the Nokma. Your honor, therefore, it is my finding there is no objection for any of the clan member. That means, my lord, clan member, including them, my lord, has to be included them, who is pleased to come before your honor, honorable court today to bear their testimony. Your honor, I will request you to kindly take into consideration the decision of the clan, and those who are unable to appear before your honor, their written statement is also enclosed along with the report. So, my lord, the entire clan, some of them they was before the EM, and some of them they have given the written statement. So, the parents of the private respondent was given the Nokmaship, my lord, after the decision made by the entire clan, my lord. Now, that was never challenged, my lord. That was never challenged by them. Now, my lord, may kindly see the next page, 29, Annexure 3A.
Yes.
This is an application which was submitted by the Hill Moza, my lord,
Yes.
after the representation which was filed by them, my lord, by the petitioner for appointing them, my lord. The relevant portion, my lord, is para 4, my lord, para 2, my lord. According to the writing and the signature produced,
Yes.
according to the writing and the signature produced by the clan member, daughter of the deceased Nokma, so and so, daughter of the deceased Nokma, my lord, may kindly see, Winji is claiming to be the daughter of last recorded Nokma, and her husband Diwan A. Sangma has taken care and nursed the late Nokma during their lifetime. If it is so, as per Achik Garo custom, they deserve to be their heirs and be registered as Aking Nokma. And it's seen that the Aking clan member have no objection to the registration of both the husband and wife as Nokma as per the writing and the signature made there too. Now, my lord, the claim was made. The report was submitted, my lord, basing on some claim made by the petitioners before this honorable court and her husband, that the petitioner number 2 is the daughter of the last recorded Nokma, my lord. That amount to suppression of facts, my lord. Now, the next page, my lord, I will try to rely After this report, my lord, the EM passed an order whereby the petitioner and her husband was appointed as NOCMA on 13/12/2003, my lord. On 13.
This is page 30.
Page 30. 3/12/2003, my lord.
Yes.
And subsequently, my lord, their name figure out in the GT, my lord.
Yes.
Now, my lord, may kindly come to page 41. It's an English translation of the letter which was written after the application by the private respondents, Maharis, was filed, my lord. This is the Hill Moza number 4 report, my lord. This is very relevant, my lord, for us. The report dated 7/6/2004, my lord. Page 41.
Yes.
Now, my lord, I will just read from the para 1.
Yes.
Re-inquiry report with regard to the appointment of Haking Nokma of Rongmalgiri, so and so. With due respect, I am presenting the re-inquiry report with regard to the appointment of Rongmalgiri, so and so Haking Nokma. On the basis of the aforesaid office order, I have on the 30/4/2014 visited the Rongmalgiri Haking and caused re-inquiry into the complaint and made with regard to the appointment of the Nokma. That means the person has gone visited the place, my lord, and then he has conducted an inquiry. Now, my lord, may kindly escape para 2, my lord. Let us read para 3, my lord.
Yes.
During the course of inquiry, the plaintiff issued an oral statement as follows: Diwan A. Sangma and his wife, Srimati Winji Mara, female, both husband and wife, falsely managed to register themselves as Nokma on so and so date. The basis of the statement on which they are registered as Nokma is wrong. The situation of the Nokma household is stated as follows. Now, Diwan, he has given the statement, my lord. Now, my lord, may kindly skip this and come to para 6, my lord. Next page.
Yes.
After the demise of late Gondrik Mara female Nokma, the near maternally relatives, consider of uncle, son, and the clan, with one mind substituted so and so female to late Raben Sangma in marriage. That means, my lord, the petitioner, the private respondent, lady female, was given a substitute Nokma, my lord, as a wife of Raben, my lord, by the Mahari, by the uncles and all, and they are the main stakeholder, my lord.
That you have stated.
No, my lord, what I am just reading, my lord. I am just explaining, my lord. So they are the main constituent body, my lord, who give a substitute wife, my lord, and they have given. So that provision or that custom has been followed, my lord, here.
So this Raban Sangma and Nosing Marak have become the Nokma.
Nokma, my lord. Yes. Now, my lord, may kindly consider para 8. Late Raben Sangma and his wife Nose Mara, female Nokma, were cared and sustained by their daughters Vatji Mara during their lifetime, as she being the heirs, my lord. So they have only one daughter, my lord, and that is, my lord, Vatji, my lord. So there is no other female issue that who can come into picture, my lord, or who can have an objection.
Yes.
Now, my lord, may kindly see after para 9, my lord.
Yes.
Moreover, the other Nokma of the 3 neighboring village also issued their statement as a witness to Srimati Vaji Marak and the complainant's party. The defendants give their statement in writing to me that late so and so female Nokma, both husband and wife, had 3 daughters, namely Rakji, Watmi, and Gongri Marak, my lord. So they have 3 daughters, my lord. The issues, my lord. Now, out of this daughter, my lord, 1J Sangma, Nokma of so and so, both husband and wife, being desirous of late so and so to be there. Here's my lord. Here's a copy. Yes. Who was the nephew of late so and so, my lord. So now, my lord, that if my lord kindly come to the GT, my lord. After page 24, my lord.
Yes. Yes.
My lord, may kindly see before Raben Sangma
Yes.
is Getrun Sangma.
Yes.
Getrun Sangma was the husband of Watmi, my lord.
Yes.
Watmi, who was Watmi, my lord? Watmi was the second daughter of the last recorded Nokma, that is Wanji Sangma and Getmi Marak, my lord. And out of these 3 sisters, my lord, the property goes to Watmi, and Watmi has no issue, my lord.
Yes.
That is why Raben was given a substitute wife, but these 2 daughters, the remaining 2 daughters, my lord, they have never claimed.
Okay.
Now, my lord, may kindly come to page 43.
Yes.
If my lord may kindly see 5th paragraph, further it is seen.
Yes.
Further, it is seen that late Raben Sama and late Nosi Mara female did not elope. The allegation of their, my lord, that they have eloped.
Yes.
Because after the demise of late Gongri Mara female, late Nosing Mara female was given to late Raben Sama as a substitute wife in marriage in consultation with the clan members of the Nokma, and late Raben Sama and Nosi Mara, both husband and wife, were appointed Nokma in the year 3/3/1965, as can be seen from the inquiry report of late so and so, and it also seen that Sri Diwan Sangma and Winji Mara female, though they are the son-in-law and daughter, is not the heirs, my lord. They was never nominated by the last recorded Nokma, my lord. Now, my lord, may kindly see the next paragraph. At present, as per my inquiry, it is seen that Waji Marak female is residing in the ancestral house of the Nokma. This is very pertinent, my lord. There is hundreds of judgments which says, my lord, a person can claim the Nokmaship if her name is there, and in addition, my lord, she has to stay with the last recorded Nokma, that is the ancestral home. She cannot leave the ancestral home, my lord. Further, according to the testimonies of 3 neighboring Nokma, Sri Diwan Sangma and Sri Winji Marak female, both husband and wife, surreptitiously registered themselves as Nokma without informing the village and the clan members and without conducting a meeting. Therefore, it is seen that the clan of the petitioner party is correct. Now, my lord, the basic thing which comes out from the inquiry, this is very not a smooth inquiry report which has been figured out, my lord, that they have, in a falsehood, my lord, they have never called for a meeting or anything. They have just submitted an application, and without a proper investigation, because even in the investigation, my lord, they have suppressed the fact that they are not the daughter and son of Raben, my lord. They claim that we are the daughter and son-in-law of the last recorded Nokma, but their parents' name was never there in the general GT, my lord. They could have managed to. Now, if something wrong has been committed, it's very apparent before the tribunal or before the quasi-judicial body, my lord. A review was filed and review order was passed, my lord, setting aside their appointment, my lord. There is no wrong on that, my lord. I don't find anything wrong, my lord, as CPC is applicable, my lord. Now, my lord, may kindly come to page 46. Page 46 is a type copy of the summon which was issued, my lord. After the Mozada report was called, my lord,
Yes.
summon was issued both the parties, my lord. My lord, may kindly see the last page. Issue summon later for both the parties for appearance in my court. So it is not the case, my lord, that it was done behind the back of the petitioner.
Yes.
Now then, my lord, what happened? After receiving of the summon, my lord, written statement was filed by the defendant, my lord. And the defendant was the petitioner, that is on page 49.
Yes.
Now, my lord, may kindly consider this 3 paragraph, that is paragraph 2, 3, my lord. 2, 3.
Yes.
Now, my lord, may kindly see para 2 that the learned court of EM Revenue had already decided the entire matter and settled white order dated so and so. Now, in the written statement, they are saying that the order was already settled, so you should not interfere with it. Now, the next para, that basing on the order dated so and so, the defendant Srimati Winji Marak and Diwan Sama has already been registered on so and so date as Nokma of Rokmalgiri. In the premises stated above, there is no point to continue the case in the present form. Therefore, the proceeding in present form be closed. There is no claim made by them. They said because an order has been passed. And if the order is wrong, my lord, they have not justified that why the order was to be upheld, my lord. That there should not be any interference with the order. They have not said anything, my lord, in their written statement.
But see, in any case, would this court, is this court required to go into this issue?
No, only
Because that would be a matter of facts, evidence.
Yes.
In the relevant court.
No, only thing what I want to emphasize is
just
this.
just to apprise the court of the background of that.
Yes. Only to emphasize, my lord, that the procedure was followed, and they have not even make a claim before the EM that why should my order should not be disturbed. Then issues in page 59, my lord, issues has been framed.
Page
59, my lord. So these are not the matter which my learned friend has argued. So I'm just pointing out, my lord.
Yes, because this will not be.
These are not was not raised before this honorable court. Now, my lord, I would like to take my lord to the my lord. The long order, my lord, I would like to take my lord to this order.
Page
67, my lord.
Yes.
The present case come up before this court challenging the registration of Diwan Sangma and his wife Unji C.H. Mara as Nokma of Romalgiri Aking. The petition for registration of Diwan Sangma and his wife Unji Mara was moved by Duran Mara, being the Chra of Chambugon clan of Romalgiri. Now, this Duran Mara, my lord, has not been made a party. The Duran Mara, who has filed an application for registration, they were never being the Chra of Chambugon clan of Romalgiri. On receipt of the petition, report was called from the Hill Mozadar of Mojan as to whether the claim made by the petitioner is correct. Hill Mozadar of Moza number so and so submitted his report before this court, being dated 18/11/2003, my lord. That I have already taken, my lord, through the report. Based on the said report, a date was fixed, and accordingly, Diwan Sangma and his wife Unji Sangma are being recorded as Aking Nokma of Romalgiri on 3rd December 2008. Meanwhile, another petition under section 7 and 8 of the Garois Autonomous District Social and Custom Usage Validity Act dated so and so was received from Min Seng C.H. Marak son of late so and so, for recording the name of Winji C.H. Marak as Aking Nokma of Romalgiri. Now, my lord, neither Mensing was also made a party. They, oh, sorry, my lord, Mensing was a party, but his name has been deleted, my lord, because it was informed that he passed away, my lord. So, but whether he had any chara who want to represent, my lord, they was never been informed. It may be mentioned that the same name of Winji C.H. Marak has been already recorded on 3/12/2003, and as such, there is no reason why there should be another petition for recording the name of the same person again as Nokma of the same Aking, unless there is some bona fide mistake. Sri Minseng C.H. Marak has filed petition under Order 1 Rule 10, read with Order so and so for amendment of his petition dated so and so on the ground, amongst other, that due to bona fide mistake the name of so and so has been wrongly written as so and so. All other contents of his petition refer in so and so only. Name of her mother, father, etc. Order dated so and so. Order number Rule 10A CPC read, whereas suit is irrelevant, my lord. Now, my lord, may kindly escape this and come to the next page, my lord. The second para, my lord. Yes. It transpired from the petition of Sri so and so, the Chra of Chambugan clan of Rongmalgiri Aking, that if his petition already met and referred to Srimati Winji Mara for registration of Nokma, then the first registration done on so and so was apparently without the knowledge of the Chambugan clan of the Aking. On the other hand, if the name of Winji was with bona fide mistake, as all other content, whereas the name of the parents, late Rasen Sangma and his wife Nosi C.H. Mara, referred to the parents of Sri Winji C.H. Mara as mentioned in the amended petition of the petitioner, it will be miscarriage of justice to disallow the petition for amendment. The amendment petition, therefore, is accordingly allowed. Coming to the next question, it is essential to know that who was the last recorded Nokma of Rongmalgiri Aking, and how and who the contesting parties are related to the last recorded Nokma. To determine the contesting party as who they are related to the last recorded Nokma of the Aking it is sufficient to trace the it should have been last two generation of Nokma as recorded in the Ambi. Ambi is the GT minor of Rongmalgiri Aking. Late so and so and his wife Watmi C.H. Mara Michik were the registered Nokma prior to last recorded Nokma late Raben Sangma and late Nosin Mara as per the GT. The inquiry report dated so and so submitted by the Hill Mozadar number so and so, which was conducted on reserve of complaint after the registration of Diwan Sangma and his wife Winji C.H. Mara as Nokma from the petitioner late Getrang Sangma and his wife late Watmi Sangma Michik. When she was still young, her name has been recorded as Nokma along with her parents, Raben. So, my lord, when she was already young, a successor was already given to the Nokmaship. Raben Sangma was given marriage to Sri Gongme Marak and recorded his name as a Nokma along with Gondri Marak, but unfortunately Gongri died in a very tender age, who was not even fit to conceive, and due to which she did not bear any issues. After the death of Gongri Marak, Srimati Nose Marak was given by the Chambugan Mahari after consensus decision as substitute wife to Raben Sangma, and her name has been recorded as Nokma along with her husband Raben Sangma. Srimati Nosi C.H. Marak died in the month of May-June 2023, but her husband died 9 or 10 years later. As per the statement of both the parties recorded during the Mozadar inquiry report dated so and so, it was admitted by both the parties that beside a son, namely so and so, who is still alive, Sri Widji C.H. Marak is the only daughter of Raben Raben Sangma and late Nosi C.H. Marak. The last recorded Nokma of Rongmalgiri Aking, the only ground of the defendant party for objecting Sri Vijji Marak is that late Nose Marak and the mother of Vijji was not offered by the Mahari as substituted wife of late Raben Sangma, but she looked him as her husband on her own. Accordingly, without the consent of the Maharis and therefore her daughters, Vijji is not entitled to become the Nokma of the Aking. It is hereby noticed that the parents of Srimati Hunji C.H. Marak is Srimati late Rak G. Marak and Sri late Rakham Sangma, whose name had never been registered and recorded in the GT. So the parents' name of the petitioner was never recorded in the GT of the Nekma of Rongmalgiri Aking. But it is noticed that while registering Srimati Winji Marak and her husband Diwan Sangma are believed and being placed as daughter of Nose Marak and Raben Sangma, which is presented by supposedly the actual facts, my lord. The Nokmaship as per Garo customary law is though the
Lineage.
lineage. Yes, madam. It should have been image of mother to the Nokna daughter or other daughters of the last recorded Nokma, and if there be no female issues, then the matter shifted going to the adoption of a daughter through the nearest female lineage. As it is the present case at hand, the true picture has been destroyed by the depriving the rightful legal heirs by misrepresenting a wrong person to be the Nokma during the last recorded Nokma of the Aking. Therefore, the registration of Winji Marak and her husband Diwan A. Sangma has been done to misrepresentation and suppression of Garo customary practice and usage of the Garos. I hereby stand cancel the registration of so and so, my lord. So on the basis of the review, my lord, that has been removed with the fact, my lord, that was been done by misrepresentation, because their parents, my lord, they cannot show in the GT that their parents' name was there, my lord. Now, my lord, may kindly come to the appeal which was filed by the petitioner. And the order was passed by the CEM after hearing both the parties, my lord. And the type copy is on page 84, my lord. This order dated 23/3/2018, my lord.
So they have appeal against that order, and
yes,
and this by this
appeal
order, the appeal is dismissed.
Yes, their appeal is dismissed, and the order of the EM was upheld, my lord. My lord, may kindly take note, my lord, whether the granddaughter of a last registered Nokma, when their parents was not their name was not inserted in the GT, can they be the Nokma, my lord? The law says otherwise. The law says otherwise because the parents has never claimed. Now, if we see the picture, my lord, of the entire issue, if the parents of the petitioner has claimed, and the matter maybe have been pending before the EM or CM, my lord, or before this honorable court, then the granddaughter can substitute their father and mother, my lord. But at present, my lord, when their parents have never claimed for the post, my lord, the granddaughter and the son-in-law, grand-son-in-law cannot claim, my lord. That is my understanding of laws.
This Winji is the granddaughter. What's the day?
My lord, the petitioner number 2 is the granddaughter. Yes.
Petitioner number 1 is the
Petitioner number is the husband,
son-in-law.
son-in-law.
Yes.
May it please, Your Lordship, I appear for respondent number 4, who is 1J Sage Marok. Lordship, I had filed a short list of events. Lordship is pleased to have.
And who are you?
I am for respondent 4.
I mean, who's respondent?
I am the daughter of the last recorded Lokma.
Oh, you're a daughter.
I'm the daughter, the only daughter. If Lordship has a, I had filed a list of events
Oh, you're what?
for consideration. Lordships have it. Filed it on 30th May.
List of events for consideration.
Yes, Lordship. List of events and points for consideration.
Yes.
So I have mentioned the dates now. If I may just take a Lordships, because my seniors have already taken the Lordships through the pleadings.
Yes. Not necessary to go into the facts again.
Yes, Lordship will kindly see the first point, Lordship.
Yes.
Lordship, the original Nokma of the Aking, undisputedly, were Katran and Watme, as Lordships have seen earlier. Now, after that, Lordship, from 3rd of March 1965 till 2nd December 2003, which is the date on which they were appointed as the Nokma, the recorded Nokmas, undisputed recorded Nokmas, were Lordship Nusing Marak and Ravan. Now, I am the only daughter of Nusing Marak and Ravan. There is no dispute with that, Lordship. Now, thereafter, what had happened, Lordship?
Yes.
At this stage, I would like to mention, Lordship, that the petitioners, number 1, are the petitioner number 2 is the granddaughter of the sister of Gongre.
Yes.
Now, after the death of Gongre,
There are three sisters.
3 sisters.
You're one of them.
Gongre was one of the daughters. Their mother Rakji was another daughter, and there's a third daughter who is not in the picture. Gongre was the registered Nokma. Rakji was never chosen as the Nokna by the original Nokma. Now, after Gongre was appointed as the Nokma, Gongre died without any issue because of her at a tender age, and thereafter Nosing Marak was given as the wife of Ravan. Now, at that stage, Lordship, Rakji, who is the mother of the petitioner, never had any objection to the registration of Nosing Marak. She could have gone before the district council and said that Gongre has died, she doesn't have any issue, I am the other sister, I should be appointed, and the matter could have been taken up. But that was never done, Lordship. From 1965 till 2003, Rakji Marak never had an objection to the appointment of Nosing Marak as the Nokma. And now I just reiterate, Lordship, that I am the only daughter of Nosing Marak. Now, Lordship, what happened? Lordship is pleased to come back to the list of events. The second point, Lordship, on 18/11/2003. 18/11/2003, Lordship, an application is filed by Duran C.H. Marak. That application is not on record. And why that application is not on record, Lordship? Because in that application, in all probability, they have misrepresented the fact that they are not the descendants.
You have the records with you, Mr.
Yes, well, CEM record is with me, madam. CM court record is with me.
In the
So when, initially you said that, when the case of the petitioner were taken up for consideration
Lordship,
as Nokma, and they were duly appointed in the year 2003. So the application was by one Duran. That application is not on
that
record.
application is not in the writ petition.
No, writ petition, but it would be on record.
Record, I don't know. Lordship.
The EM court record is not with me, madam. CEM court record is.
But that would be necessary
That I will place it, madam, before the.
because now I think at some point of time, though it's not there in the pleading, you have questioned the bona fide of Duran
Yes.
as to whether he is one of the Maharis or one of the Shara, whatever. Anyway,
So
please continue.
that application is not part of the writ petition in all probability, because that application probably would have had some suppression of facts which have been found in the Mozadar report pursuant to that application. Now, in that Mozadar report, Lordship, the Mozadar finds that Vinji C.H. Marak, who is the petitioner, is the daughter of Nosing and Raban.
She claimed to be the daughter of
Because she claimed to be the daughter of Raban and Nosing.
Muslim.
And 2003, that Mozadar report submitted that report saying that petitioner is claimed to be the daughter. The earlier Nokmas have died, so no impediment to register as the Nokma. Lordship, accordingly, in pursuance to that, in 3rd December 2003, both the petitioners were appointed as the Nokmas. However, in the order passed by the EM in December 2003, there is no indication of which is the uncle Lordship. He filed an application for registration of the respondent number 4. In that application, Lordship, the entire history of the original Nokma, the substituted wife, and the consent of the Chra and the Mahari were spelled out in that application. However, because of probably a typographical error, instead of WATJE, it was typed as WING. That was the only error in the application. Now, however, in the application, clearly it was stated that Vatji is the daughter of Raban and Nosing, and she has been duly approved by the Mahari or selected by the Mahari, as well as the previous Nokma, to be the successor Nokma. Lordship, the application was filed, and on seeing the application, the EM thought it fit to go for a re-inquiry report. It is a settled position of law, Lordship, that any order obtained from any authority which is obtained by suppression can be set aside at any stage. It is honest. An order obtained by suppression of facts or by fraud has no validity in the eyes of law, Lordship. Which is why the EM, seeing the nature of the dispute,
has taken note of that fact.
Has gone for a re-inquiry. In the re-inquiry, Lordship, clearly it has been found by the concerned Mozadar that respondent number 4 is the only daughter of the last recorded Nokma, and that she has been approved by the Shra, and at the same time it has been also found in that inquiry, Lordship, that in 2003, when the petitioners got themselves registered as Nokma, that was done by utter suppression and misrepresentation of the facts, and without the consent of any of the clan members. Now thereafter, Lordship, the inquiry gave a finding in 2004 that respondent 4 is the rightful successor to the Nokmaship, being the daughter of the last recorded Nokma, being chosen by the Aking clan to be the Nokma, Lordship. Now, Lordship, after the re-inquiry report, notices were issued by the learned EM to both the parties. They came and appeared, they filed their written statement. The written statement, Lordship, they made a single point that I have already been registered as the Nokma in 2003. No challenge to the inquiry which was made, which found that they have done it by misrepresentation of the facts, Lordship. There is no counter, neither before the EM at that stage, nor at this stage in the writ petition, that the finding of both the EM and the CEM, which says that their registration was done by misrepresentation. There is no counter to that, Lordship. They are on technicalities. Now, Lordship, what happened? Thereafter, I filed Min Singh, who was respondent 3, who had filed the application, filed a rejoinder to their written statement, again reiterating that their registration was done without the consent of the Mahari, and in the rejoinder also, all the references which were made were clearly towards what JCH Marak, and the name was also filed, Lordship. However, in the original application, instead of what J, it was still mentioned as Winj. Now thereafter, Lordship, suggested issues were filed, framed, parties were heard. In the meantime, before the passing of the judgment, Lordship, it was noticed that the original application which was filed still had the name of Winj, whereas it should have been what J, and all the other references were towards what J only. So an amendment application was filed, Lordship, under Order 1 Rule 10 read with Order 6 Rule 17 for amending the original petition. The only amendment that was sought for was the correction of the name from Winj to what J. No facts, nothing. Lordship, thereafter, Lordship, under the spirit of the CPC, an amendment, Lordship, may be allowed by any court if the court deems it fit that it would help the court to decide the actual matter in controversy, Lordship. The purpose of the amendment is to go to the root of the case and to give a just decision of the case. It is not to stop a party in technical grounds or not. So the amendment was taken up along with the main matter, and the EM Lordship rightly allowed the amendment on the ground that it was only for a correction of name. So it is considered to be a typographical error, does not cause any prejudice to any party. Application for amendment was allowed, and further on the basis of the pleadings and the Mozadar report and the other material on record, has passed the order, Lordship, on 23rd of August 2016 with the following, with these findings that, Lordship, that number one, petitioners have no right to claim for Nokmaship because they do not belong to the, they are not the descendants of the last recorded Nokma. They have also, PM has also given the finding, Lordship, that on the perusal of the records, it appears that the registration of the petitioners as Nokma in 2003 was done in utter misrepresented manner without knowledge of the concerned Aking, and it was done in a very fraudulent manner. And thereafter, Lordship, it was also found in that in the subsequent inquiry, the claim of the respondent number 4 as the daughter chosen by the Aking to be the successor during the lifetime of the last recorded Nokma was found to be correct, and hence under the Garu customary law, Lordship, she was entitled to succeed the Nokmaship. And in such view of the matter, Lordship, the registration of the petitioners which was done in 2003 fraudulently was set aside. Lordship, they filed an appeal not disputing the fact or the finding of the EM that their registration was done fraudulently. They again reiterated the technical proposition, Lordship, that amendment was at a belated stage and that I have already been registered in 2003. Appeal was admitted, Lordship, and the written statement was also filed by the respondents. And after the lengthy hearing, Lordship, by way of an order dated 23rd of March 2018 passed by the learned chief executive members, a concurrent finding was given upholding the order of the EM. Now, Lordship, my submissions I have given at page 11 in very short synopsis, Lordship. May be pleased to note it. Page 11 of that list of events.
Yes.
The first submission, Lordship, is that the petitioners are not from the lineage of the undisputed last recorded Nokmas, which is Raban and Musi. It is not their case that, Lordship, my second point is that respondent 3, who was the Chra, had filed the appointed as the Nokma, being the only daughter of the last recorded Nokma, and chosen by the Chra and Mahari to be the successor Nokma. Third point, Lordship, is that the petitioners had gotten themselves registered as Nokmas in 2003 by misrepresentation of the facts, and they have also not placed their application on record in the writ petition. It was misrepresented, Lordship. Fourth point, Lordship, is that the orders passed by the executive member as well as the chief executive member are after proper representation of the facts and material and after proper adherence to due. And it is not even their case that these things were, there was any infirmity with the procedure. Number 5, Lordship, is that there is a concurrent finding of both the CM and the EM, which is based on sound principles of Garu customary law, and after giving adequate opportunity to both the parties to place their case, Lordship. And therefore, Lordship, concurrent findings of both the EM and CEM filed a petition under Order 1, Rule 10, read with Order 6, Rule 7. Filed a petition under Order 1, Rule 10, read with Order 6, Rule 17 and Section 153 CPC. Should have been 151 CPC for amendment of his petition dated so on the ground, amongst others, that due to bona fide mistake, the name of Srimati Vidji C.H. Marak has been wrongly written as Winji. So there's a mistake of one letter. All the other contents of his petition refers to Vatji only, name of a mother, father, etc. so and so. Now EM has quoted Order 1 Rule 10 Lordship, where a suit has been instituted the name of the wrong person as plaintiff, or where it is so and so, the court may at any stage of the suit, at any stage, Lordship, if it is satisfied that the suit has been instituted through bona fide mistake and it is necessary for the determination of real matter in dispute, so to do any other person to be substituted or added as plaintiff upon such terms as the court thinks just. Order 6 Rule 17 CPC says court may at any stage of the proceeding. Order 6 Rule 17 CPC says court may at any stage of the proceeding allow either party to alter or amend his pleadings in such manner or such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real questions in controversy between the parties. Worship may kindly come to the next page, page 69. It transpired from the petition of Sri Minsing, the Chra of so-and-so clan of so-and-so king, that if his petition really meant and referred to Vinji for registration of Nokma, then the first registration done on 3/12/2003 was apparently without the knowledge of the clan of the Aking. On the other hand, if the name of Vinji was bona fide mistake, as all other contents, that is the name of the parents late Raban and his wife Nosing C.H. Marak refers to the parents of Vatji C.H. Marak, as mentioned in the amendment petition of the petitioner, it will be a miscarriage of justice to disallow the petition for amendment. So as far as the amendment is concerned, Lordship, the EM holds that apart from a typographical error of the name, all the contents of the application were correct, and to not allow that amendment to only change the name would be a miscarriage of justice, Lordship, which is why the EM has allowed the amendment. And with regard to the issue of who is supposed to be the Nokma, Lordship, the issue is that the EM has also given the finding that petitioners have no lineage from the last 2 generations of the undisputed recorded Nokmas. At this stage, Lordship, they cannot claim for Nokmaship, and that their registration, which was done in the year 2003, was done with suppression of facts and against the principles of Garo customary law. The case of Chelish Sangma one more time. Chelish Sangma, Writ Appeal 43.
Yes.
His Lordship is pleased to come to para 5. Paragraph 5, may I quickly read, Lordship? Paragraph 5 at page 5. The appellants. Lordship, if I may read, the appellants do not file opposite affidavit in opposition to the petition stated in the present memo of appeal that the facts in this case, Lordship, the last recorded Nokmas of so-and-so King were Khiljing Marak and Nema Sangma. After the death of Nema Sangma, as per Garo customary law, Srimati Thame Sangma was given as substitute wife to Khiljing, and the name of Thame Sangma was entered in the GT. Thereafter, Shri Khiljing died, and Thame Sangma substitute wife married one Rasan R. Marak. Srimati Thame Sangma died, and thereafter Rasan Marak, who was given as husband to Thame Sangma, married one Srimati Menji Marak. Rasan Marak and Menji Marak had a daughter, Donme Sangma, who married one Parkin Marak. After the death of Rasan and Srimati Menji, Sri Parkin Marak applied before the executive member so-and-so for appointing him as the Nokma of so-and-so Aking. Rasan R. Marak, the husband of Thame, had approached the DC so-and-so for record, and Khiljing Marak had 3 daughters, namely Khanji Sangma, Noan Sangma and Kalse. Appellant number 1 is the granddaughter of Nema Sangma Mechik, and appellant 2 is the husband of appellant 1. Appellants and the others file objection dated so-and-so against the petition filed by Parkin and his wife Dome for recording as Nokma of so-and-so Aking. In their objection, it is stated that according to Garo customary law, Maharis have to elect the one who is to become their Nokma. In their objection, the appellants and others did not state that the undisputed owner of so-and-so Aking, Nema Sangma, did not appoint any Nokma for so and so Aking, and as no Nokna was appointed during the lifetime of so and her husband so and so, Maharis have appointed the Nokma. The objection, they have reproduced the objection, Lordship. Now lastly, Lordship will kindly come to.
So you are citing this case to draw an analogy.
Yes, I am trying to say that in this case also, Lordship, the original Nokmas were Neme and Khiljing. Once they died, a substituted wife was given. Then substituted wife died. A substituted husband was given. Then they had a child who was Donme, and Donme married Parkin. Parkin went to apply for Nokmaship. The granddaughter of the original Nokma objected, saying that it should have gone back to her, and the issue was, the decision was against the granddaughter, Lordship, that since the appointment of the parents of Parkin and Donme, which was Rasan, was never disturbed, right from 1935-36, at this stage it cannot go back to the persons before that, Lordship. Here in the case, what their contention is that Watme, who is the original Nokma, had 3 daughters. Gongre died without any issue. Substituted wife could not have got the Nokmaship. It should have gone back to the second daughter, which is their mother. The mother has never objected, Lordship, right from 1965 to 2003. And now at this stage, they are the granddaughter and the grandson-in-law of original Nokma, which is Watme. They don't have any claim, Lordship, because their parents never claimed nor filed any objection. And in any case, right from 1965 to 2003, it was my respondent's parents who were the undisputed Nokmas chosen by the Mahari. And after their death, the present respondent number 4, Lordship, was chosen as the Nokna during their lifetime, approved by the Aking. It is nowhere their case, Lordship, that the Aking has chosen petitioner number 2 or her mother during the time of the last recorded Nokma to be the Nokna.
Yes.
So, Lordship, the writ petition may be dismissed, Lordship.
My Lord has passed in judgment sitting in the division bench, where my Lord has dismissed the case on the ground that the petitioner was sleeping over his right, the Nokma matter, sleeping over the right for 30 years. In this case also, my Lord, the petitioner, when the father and mother of the present private respondent was appointed as the Nokma, my Lord, the petitioner and her parents, my Lord, they were sitting over their right. They have never come before, my Lord. And there is a judgment, my Lord, where the Honorable Chief Justice with my Lord has passed an order. I'll place it tomorrow, my Lord. I'll pass it today itself, my Lord, a copy of the judgment. I have a copy of it.
If that is the case, Your Lordship, if I may produce just one citation before Your Lordship. Just one citation.
What do you, as is usually the, I would say by now, practice, file your argument in written form. You have
They have
filed
already submitted.
No, I have not submitted my argument. Only the gist of dates, case
with
dates.
with the authorities.
It may be that Your Lordship may kindly allow that way, like we can submit it.
There's no issue, my Lord, we can submit.
That records.
Yes, my Lord.
Can you produce it?
Yeah, I have the CEM record right now, my Lord.
No, the EM record.
EM record, my Lord, then I will pray for 10 days time at least, my Lord, from Garo office. I will send a letter, then they will send a special messenger to send me.
1 week will be enough.
One will be enough, Your Lordship, because like how
Now
fast-
that record, my Lord, 1 week. If again after 1 week I will come.
if the court's order is there, they will look for it, Lordship. By tomorrow also they can produce it. Your Lordship, if I may just produce one citation, Lordship. Just one citation. I'll
Yes,
take just 2
no.
minutes. Lordship, only just 2 minutes. I'll take only 2 minutes, Your Lordship.
Okay, fine. You want to. Since you said that you want to file your written argument,
You will file your return argument.
If Your Lordship, so ask Your Lordship.
Yes, putting the.
Your Lordship, page 5, Your Lordship. Page 5.
What is this?
Yes, it's page 5, paragraph 4, Your Lord. Page 5, paragraph 5, Your Lordship.
let me note down.
SCC. Page number?
If I may read, Your Lordship,
Yes, ma'am.
Page 782.
paragraph 5.
SCC.
A small one, Your Lordship. It is true that the jurisdiction of the High Court
Just a minute.
Sorry, Your Lordship.
Paragraph 5, yes.
Yes, page 5, paragraph 5, Your Lordship.
Yes.
Only half of it, Lordship. I read within the limits of the respective jurisdiction. But it's all Your Lordship, because in my humble submission, the only question that calls for determination is whether the Garo Hills Autonomous District Social Customs and Usages Relativity Act 1958, which governs all disputes relating to Nokmaship and the outcome boundaries thereof, does it prescribe the power to review? Because the power to review is not an inherent right. It must be conferred by law, specifically, or by necessary implication. And in my humble submission, the Act has not prescribed the power to review. That is all, Your Lordship.
Replying to my friend, the last one word, my lord. Munising T. Sama. That is a law laid down by the Honorable High Court, which direct, my lord, that CPC in spirit has to be applicable. If CPC is applicable, then my lord, review lies, my lord. This is a law laid down by this Honorable High Court.
Yes, that is true. But how that is to come about? Because apparently the proceedings in question came about. It has come on a petition filed by, I don't know who was filed. Somebody has filed, and reference was made to the earlier order.
Yes.
So perhaps in that way we have to see as to whether it amounts to a review or it amounts to a fresh application, ignoring the earlier order. All those things. See? So basically, there are some issues of law to be decided.
Even if the Act doesn't mention, it is to say also the established principles of judicial procedure is always there.
But you see, if we go by the Dore Sangwa case also, where principle of CC, natural justice has been followed.
Yes.
So that
If that is why I said, Lordship, that the order obtained by suppression of fact has to be.
My lord will be, if I can put in a very common language, my lord will be hit by my lord's order. Where my lord has stated 30 years back case, you are sitting tight over that. Now, my lord.
that is only deciding on the issue of delay latches
Yes.
and acquiescence.
Yes, my lord. And
If it is
here also
applicable-
there is a delay, my lord.
If it is applicable, fine.
Yes, my lord. Yes, my lord.
So
10 days, my lord, I will pray. 10 days, my lord. And on the meantime, if my friends and we agree, then we can submit a written argument also.
please do.
Okay, yes, Your Lordship, please.
All the parties have been heard in this matter. At the conclusion of the hearing, the learned counsel has submitted that they may be allowed to file a synopsis of their argument advanced before this court. This standing counsel, GCDC, has submitted that he may be allowed to produce the said record on the next date fix. Yeah, son. This is matter on 6th.
My lord.
6th, that will be 10 days or so.
Yes, yes. So, my lord, two matters of the Nakma, we have washed our hand. Now it's before my lord to decide. One more matter was there where my lord has CAB, I think, on that matter also. One matter also. Mr. P.T. Sarma and I argued the matter. That also now is before my lord's court to decide. And these Nakma matters are not so easy, my lord. It look very easy. But to get hold of it is very difficult, my lord.
True. And we don't know, you see, actually, there must be some, apart from the Dore Sangwa case,
Yes.
there must be some prescribed procedure
Yes.
to be followed by EM or
Yes.
CM. And suppose now, for discussion's sake,
Yeah.
after order passed by the CM, you see what remains. Whether you see, it is to be proceeded by review, by a revision or an appeal, and what would be who will be of course, it is only the High Court that can take up the matter, even
No, revision.
as an appellate court, because of course under the provision of the jurisdiction of the High Court over the district
But I
council.
understand, my lord, revision is bar, my lord, because this is not a court. Only the court's order can be filed in the revision, my lord.
That is
That
also
has
what
been
it is.
decided by this honorable court.
Yes, yes, yes.
Now, my lord is taking up the application of 226 as a second appellate forum, my lord. Because the first appeal lies before the CEM. Now, my lord is the second
Exactly,
appellate forum.
exactly. If it is as straightforward as that, then this court can appreciate the evidence.
Yes, yes, my lord.
But it cannot
But the law says otherwise.
do. It cannot do. So as Mr. Sangwa was saying, you see, now the only question is the court has to go into the propriety or impropriety of the impugn order
Yes.
pass.
Yes.
Anyway,
It will be interesting.